Both will have 15 minutes to present your arguments to the court. And if the appellant would let me know if you want to save some time, because I'll try to watch the clock for you for rebuttal. And also, I want to remind everybody that we don't talk about victims' names. We don't mention their names. We use initials or refer to them as victim, or we, just like I said, don't mention their names. We also don't mention names of any minors. I just like to always make sure that those ground rules are laid out so that everybody understands in case something might arise. Okay. Mr. Dixon, you ready to proceed?
I am, Your Honor.
Okay, like I said, you have 15 minutes, and if you want to reserve up to 5 minutes, let me know.
Thank you very much. Good morning, Your Honors. My name is Robert Dixon. I represent the appellant in this case, Mr. Eric Korn, who this morning continues to serve his 11-year sentence in an Ohio correctional institution. I would like to reserve 5 minutes of my time, if I may, for purposes of rebuttal.
That's fine. Thank you.
Thank you. Your Honors, this case arises from Mr. Korn's conviction for possession of drugs. And he was convicted and sentenced to an 11-year sentence. This was a jury trial in the Lorain County Common Pleas Court. It was presided over by visiting Judge Thomas Picorni. We've raised several issues for the court that all kind of revolve around a factual matter that I believe was never properly fleshed out in the trial court, and I think is critical to at least two of our, or probably three of our issues. And that is this. This case was indicted in May of 2016. It did not find its way to trial until August 27th of 2020, over a 4-year period. There was a number in the record, a number of written waivers of speedy trial, which appeared to be executed either by counsel or the defendant or both. I'm not sure about that. However, I think there was something like 24, probably an unprecedented amount of waivers of speedy trial and continuances. In my 30 years, I don't know that I'm sorry, 40 years. I'm not sure that I've seen a case continued this many times, pandemic or not. The defense contended in their motion to dismiss for speedy trial, as well as their motion for continuance, that they only entered into these continuance agreements and waivers based on the state's representation that they were having very numerous wiretap recordings of the various defendants in this case. And there was 4 or 5 other defendants in this matter, all separately indicted for the same offenses. However, the state obtained a wiretap, and we don't take any issue with that at all. But they indicated to the defense, at least according to defense counsel on the record, that time and time again they were told that these were being translated and prepared and would be given to the defense. As it turned out,
Counsel, Counsel, on that issue, I was going to ask you if that was in the record, and you just said that it was. Can I assume that was like during pretrials, or in what context? And then my second part of that question would be, what was the state's response or conversation as to that during the course of this 4 years? Yes.
Well, again, I don't think that this, as the record stands presently, and I think that's part of the problem and why we're here today, part of the reason anyway, I don't think the facts were clearly fleshed out. It is clear from the record during the colloquy on the motion to dismiss held shortly before trial that defense counsel Joseph Morse asserted that he had been told over and over and repeatedly by the prosecutor that had handled the case that they would be preparing these translations of these critical calls. The prosecutor handling the case countered and said to the judge, Well, I didn't handle those negotiations, but I talked to the people, the prosecutors on the case before, and they told me that's just not true, that we made no such promise. Well, that's a very stark factual dispute, I would say. And Judge Picorni, much as I love Judge Picorni and practiced before him many, many times, he just failed to resolve that critical factual dispute.
Well, counsel,
Why is
I want to
yes.
circle back then to the original part of my question. And
Yes.
It sounds like you're suggesting the trial court should have delved into it more. And I don't, moving aside from that, for purposes of our review and looking at the record, during the course of this 4 years pretrial, I mean, were things put on the record during the pretrials or appearances or anything that happened during, I mean, certainly this case just didn't sit idle for 4 years. Something was going on. Is there anything that we, in doing our review, will find on the record that would even, suggest that, okay, this is why, we're delaying this. We're still working on these translations?
I could
By
find
we,
nothing.
I mean the state saying it was going to do something.
Understood, Your Honor. And I could find nothing. The waivers of speedy trial that were issued were pretty generic in nature. And I'm not even sure the parties were appearing in person. I can't say any indication. There's from the transcripts filed by the court reporter, and we asked for a complete record. There's no transcripts of those kind of hearings. So I think it was probably done remotely or by entry alone, and I don't think any good record was made at the time they were done. That's my understanding.
Does the record, in your review of it, contain any type of motion from the defense to get these recordings translated?
No, there is no such motion other than on the eve of trial when the state, and this is what happened, was the state basically on the eve of trial dismissed the racketeering counts, the conspiracy counts, and at that point argued that, well, these recordings are no longer relevant. Judge Picorni agreed and said, you only need to produce for the defense those recordings you're going to use in the trial. Well, now the trial had been very severely truncated because they dismissed these other counts. So I think that's the only indication we have in the record regarding this, Your Honor. Does that answer your question?
Yes, sir. Thank you.
Okay. So our first issue is that the court, that the defendant was denied his right to statutory and constitutional speedy trial. And our argument is very basic and argues that we, the defense, only entered into these waivers because of the promise that these tapes were being prepared, and the defense felt they were critical for them to have to adequately prepare their defense.
Counsel, let me ask you about that as well. Judge Callahan asked some questions I was going to about the record, so I think I understand now what is or is not in the record, and obviously we'll be reviewing it as well. But I'm just a little confused. You're relying on these transcripts. At some point, maybe a way to get the state to stop dragging their feet is to say, I'm not signing any more waiver of speedy trial, because you're going to have to either go forward without these transcripts or you're going to have to turn them over.
Your Honor, it appears, and I think there's reference to this in the record, that there was just a huge amount of recordings and intercepts in this case. And the defense position, which I think was never adequately disputed below, that Mr. Morse took, was that they were told all of these were going to be provided. and that time would be needed. And it was understood that that was probably a lengthy process. So I think for that reason, the defense continually entered into these waivers. If you look at page 74 of the transcript below, and this is quoted at page 13, I'm sorry, page 15 of our brief, the brief of the appellant, Mr. Morse says the following: the only reason, it's kind of being put in a bad position of, well, we have all these phone calls, we have all these intercepts. It's the basis of the investigation. We're having problems. We're having this, we're having that. You need to waive time so we can get them to you, right? Well, that's an inducement. And that inducement kept happening and happening and happening. Now, that's the statement of counsel who was involved in this case. The state's only counter to that assertion was that, well, I talked to the prosecutor to handle this before, and they said, that's just not true. So I think it was incumbent upon Judge Picorni to not leave it up to this court to try to decipher this issue or get to the bottom of this factual dispute that I think is critical to these issues. Judge Picorni said only the following, and again, this is at page 15 of our brief. I've heard enough. The motion to reconsider the court's ruling on the motion to dismiss is overruled. The motion to continue is overruled as well. Look, these are legitimate issues that the defense has raised here. I've made my decision on it as best I could. It was not done in haste. I thought about it a lot. I reviewed some law, and that's as good as I can come up with. But there are issues, and they're legitimate issues, but that's not for me anymore. That's for some other time. Well, I don't know if Judge Picorni meant that this is that other time for that to be decided, but.
Counsel, I was just going to alert you to the fact too that you're at your 5-minute
okay.
rebuttal time. If you want to continue, you may.
No, I'm confident that we've set forth the arguments in our brief and that this court will carefully consider those. So I'd like to save my time for rebuttal if I may.
Thank you.
Judge Carr, if you don't mind, I have a question on that last comment. Counsel, I know what you're saying now, and in your brief is that possibly this should be remanded for the trial judge to sort all this out. But are you really talking about trying to get into things that were not part of the record, evidence outside the record, basically, since we've already kind of established that I'm not going to find this in the record? And is that appropriate for direct appeal?
Well, it would not be, I don't think, appropriate for direct appeal, and we still are timely to file a post-conviction in this case. However, our position is that a remand would obviate the need for that, and this court should remand because it cannot fairly decide this case based on the lack of fleshing out the issue by Judge Picorni. So, and quite honestly, we think we're right in our arguments, Your Honors, but I don't know that this court can really decide it without resolution of that factual issue, and remand would probably be a good remedy for that issue. Thank you.
Thank you.
And Mr. Murphy, you may begin.
Thank you, Judge. And I didn't get a chance to say good morning to Bob. It's good to see you again, Bob. I haven't seen you in a while. Responding to Judge Callahan's question about a remand, remand's absolutely unnecessary in this case. What a remand would do is give a litigant, in this case, Mr. Korn, a second chance at litigating his case. And actually, it would be a third chance. So let's be clear. The record in this case doesn't start until August of 2020, right before the trial, short of there being an arraignment transcript, I think. There are, to the best of my recall, there is absolutely no record created between a first pretrial and essentially the motion to suppress hearing and some things that happened just moments before the motion to suppress hearing. Trial counsel in this case represented Mr. Korn at arraignment through trial. So he had every opportunity, Mr. Morse did, to create whatever records he wanted to, and to, as either Judge Carr or Judge Callahan pointed out, I think it was Judge Carr, to decline to sign any more speedy trial waivers, or to advise Mr. Korn that he should not waive his right to speedy trial any further. What this all comes down to, actually, judges, is you're correct. There is absolutely no record about about the issue that Mr. Korn's raising here. There is no record of it. The only record is what Mr. Dixon recited a little earlier today during this hearing, and all that is that is simply his statements. That's not evidence. What he needed to do, if this was all accurate, was create a record much earlier, or, as I think Judge Carr pointed out, refuse any more speedy trial waivers and file a motion in limine that says the state can't use this evidence, right, Judge? And have him make a preliminary ruling. And in fact, the judge did make a preliminary ruling on the translations of these intercepted communications that were in which Spanish was being spoken. There was a motion to compel filed February 24th of 2020. Judge Picorni ruled on the motion to compel on March 10th of 2020. The ruling is in the record. Judge Picorni indicated to the state what it was required to turn over. And as the record's clear, what Mr. Korn was seeking to do on the eve of, not even on the eve of trial, but moments before trial started, was to relitigate. He was asking the judge to reconsider the March 2020 ruling on the motion to compel. He wanted more than the judge was willing to give him, or wanted to give him, or believed was necessary to give him. There was no what Mr. Korn was trying to do essentially was delay the matter even further. And now he's sitting here saying that his right to a speedy trial was violated. I mean, just juxtapose the first assignment of error of a right to speedy trial being violated, despite 21 waivers that he signed over the course of time with the same trial counsel representing him over that time, versus the motion to continue, which says, I need more time. But the only reason he needed more time, and by the way, 3 of these assignments of error are basically predicated on the intercepted phone calls in which Spanish was being spoken. And they're essentially based on the motion to compel being much more limited than Mr. Korn wanted. The second assignment
Counsel,
of error is...
can I stop you for a second, because I'm getting a little confused. Maybe you can refresh my recollection. In regard to the motion to compel, what did they actually ask for?
I believe that I believe, if my memory is correct, that that Mr. Korn wanted every single one of these thousands upon thousands of intercepted calls, if there was Spanish spoken in them, translated at state's expense.
The motion to compel. Okay.
Without any showing, by the way, Judge, without any showing by Mr. Korn that they were relevant. I mean, look, the state turned over these calls. There's no indication that the state did not turn over these calls to Mr. Korn and the defense. Thousands upon thousands of calls are being turned over. I mean, if thousands upon thousands of documents are turned over to a defendant, the state doesn't have to go in there and read them. Now, I understand they may be in English and it's time consuming though, but it's incumbent upon the defense to read thousands upon thousands of documents. These calls are in Spanish. The least Mr. Korn could have done, if there was some kind of prejudice here, if he believed that they were relevant, would have been to listen to the calls himself with someone who speaks Spanish and make a preliminary showing to the trial court why it was necessary that the state paid to have thousands upon thousands upon thousands of calls. Mr. Corn could have asked for a court-appointed translator paid that the court paid for. He didn't do that. There is absolutely no showing in this record that these calls were relevant. The calls, that the motion to compel told the state I think clearly relevant phone calls, which would have been calls that the state intended to introduce or that were exculpatory to either Mr. Corn or co-defendants, and also existing police summaries of intercepted calls. So any Spanish speaking calls that had been summarized, and both those had to be in English, and the first aspect had to be verbatim according to the trial court's order. And let's
Counsel,
remember.
let me just ask you another question in regard to these. These intercepted calls, the ones that were in Spanish, was the appellant involved in those? Was he on that particular call, on those calls?
I don't know.
Well, the reason I'm asking is because if they were in Spanish and he was participating in them, if he spoke Spanish, in other words, if he understood and spoke Spanish.
I don't know.
Okay.
The record doesn't say it. The record doesn't say whether he did. And also, Judge, though, the motion to compel, the judgment from the motion to compel told the state that even if Mr. Corn were speaking Spanish, the state was required to translate those and provide them to Mr. Corn. So he couldn't be prejudiced there. It was part of the court's order. Which brings me to my next point, Judge. That court order was never appealed, is not part of this appeal. It's not being appealed. So Mr. Corn has no issue. He's asserted no error with the motion to compel. So he's piggybacking multiple arguments on something that is not error in his opinion. He's piggybacking this inducement argument, which in his first assignment of error, this inducement argument on something he hasn't asserted error with. And by the way, this is a unilateral decision. The state's not involved in any decision whether he's going to waive time, that speedy trial time.
You're saying that because there's nothing on the record?
Sure.
Okay.
Right.
Let me ask you this. Is there anything on the record why this case was continued so many times?
Yeah.
I mean, this is very unusual. Sure.
There's 21 journal entries that show why it was continued. Mr. Corn signed speedy trial waivers.
Well, just because somebody signs a speedy trial, it may be detrimental to the state to wait to spend all that much time before prosecuting its case. As we know, the evidence gets stale, it gets lost, whatever.
Certainly. You're absolutely right on that. And look, I'll speculate in this case, maybe the state didn't feel that way. It's a drug case. There were drugs found in a garage.
Okay, so there's I'm just going to stop you because we don't want to, speculate. So there's nothing in the record that says anything about anything in regard to why the case was continued so many times.
Correct, Judge.
Because I assume it was set for trial, and as the record, we saw that in the brief. So
3 times it had been set for trial and continued at Mr. Corn's request. Obviously the continuance argument is also predicated upon this motion to compel, which again, Mr. Corn took no issue with, asserted no error regarding that judgment. And so to say that Judge Picorni didn't deal with this issue, I think is inaccurate. Judge Picorni did deal with the issue. He addressed the motion to compel. He issued an order. That order is not being appealed. It can't stand as the foundation for other asserted error here. It's also asserted error in the 5th assignment of error regarding the search warrant and probable cause. in which, basically, there's an argument that he needed these intercepted calls to determine whether there was probable cause in the search warrant, which is, of course, a twofold problem. Frankly, the real error that the trial court committed here was even having a hearing on the motion to suppress. There was absolutely no reason to have a hearing on the motion to suppress. There was no indication, there was no assertion even. The word Franks never appeared, Franks or any allusion to the Supreme Court's holding in Franks regarding intentional falsehoods or reckless disregard of information, that never appears in the motion to suppress. Never. There never should have been a hearing in this case. The probable cause should have been determined from the four corners of the affidavit. And based on that, there was then no reason that probable cause was determinative from the intercepted calls and the Spanish, the words spoken in Spanish from the intercepted calls, because that was never asserted to have been in the to have contributed to the probable cause in the affidavit. The whole argument here, I think, as this court has, as you have observed, the whole argument goes to a lot of things that are not part of the record. And there was plenty of time for defense counsel, for Mr. Korn's trial counsel, to develop that record if indeed that's what was happening. He didn't do so, and at the last minute is now trying to rehash arguments that Judge Picorni had already heard, had already considered once before, albeit apparently either just based on the briefs or without going on the record. Based on this record, there's no reason to remand. There was no, the right to speedy trial wasn't violated. The motion to continue was predicated upon a decision that the judge had already made. The ineffective assistance of counsel can't be predicated upon the fact that he didn't have these intercepted calls translated into Spanish, because the judge had already ruled on that matter. There's no indication that trial counsel performed poorly. In fact, Mr. Korn goes out of the way to try not to assert that trial counsel performed poorly, but that he was induced into performing poorly. The probable cause determination had nothing to do with the Spanish spoken, whatever was spoken in Spanish. And lastly, as far as the sentencing hearing goes, frankly, if you didn't, again, the word prejudice never appears in Mr. Korn's argument. He has to show prejudice under this court's precedent. He never attempts to assert prejudice. Frankly, if you read that sentencing hearing without, I'll be done in 1 second, Judge Carr.
I was just going to say, you know my facial expressions.
I'll be done in 1 second. If you didn't know that Mr. Korn wasn't present in the courtroom, that sentencing hearing looks unlike any other sentencing hearing that occurs on a daily basis in courts across Ohio. So the state asks that you affirm the judgments and conviction of Mr. Korn. Thank you.
Thank you. Mr. Dixon, you do have just a little over 3 minutes remaining.
Thank you very much, Your Honor. Your Honor, to whatever extent that there's a suggestion here that Mr. Morse should have pressed this issue more forcefully, I think that that's not appropriate, because Mr. Morse indicated, and this was not disputed, and the court didn't resolve this issue. He said that he went along with these continuances solely based on the state's representation that they would produce these translations that he felt were necessary for his case. And he did even argue in the motion to suppress that even for that purpose, they were important, because the detectives testified in that hearing and he gave conclusory statements as to what he felt these recordings indicated. And the defense was powerless to really dispute that. So Mr. Morse, even to that limited extent, said that he needed to get his hands on those. What I've heard is a lot of speculation about what the parties wanted to do, what their motives were, who said what, why were there so many continuances. Again, the defense asserted why that was. The defense felt that the rug was pulled out from under them at the last minute here, that the state had made representations for years about this, that they anticipated and needed these recordings. The state's only counter was, well, I talked to some guy who said, no, we never made a quote promise. Well, that issue really needed to have been resolved. And I'm not sure that this court is in a position to decide this case without a remand to the trial court for resolution of that issue. If we are correct on an issue, then I think there's some legitimate issues to be decided by this court relating to a speedy trial, relating to whether or not the defense should have been granted continuance so that they could do what they needed to do. We've cited at page 19 of our brief, this court said in RH versus GH, denial of a continuance can have grave consequences when it relates to the ability to mount a defense. And that follows Unger versus Serafide, US Supreme Court, also cited in our brief. So I think there's some very legitimate issues that have been raised here. Unfortunately, they may be predicated on resolution of fact, which was just not done below. And I don't think it's appropriate for this court to try to resolve those facts. It should be remanded at very least for resolution of those issues. So unless there's any further questions, I would conclude my argument at this point then and thank the court. And also Mr. Murphy as well. Good to see you, sir.
It's nice to see such collegiality. Okay, we will take the matter under advisement. I do thank you. The court does thank you both for your arguments to the court today. And we will take the matter under advisement, issue a written opinion that will be sent to both sides, and we also release it on our website electronically. Thank you very much, and I hope you both have an enjoyable rest of your day. Bye-bye.
Thank you.